ये पूरा मतलब अपलोड करूँ जब नाइन फोर सेवन नाइन फोर सेवन तो दूसरी पड़ेगा हम लोग हाँ जी सर, मैंने वो भेजा है चेंज करके। हेलो। सिलेबस का, और मैंने बिजनेस लॉ के पेपर का भी भेजा है, और इसमें कॉन्स्टिट्यूशन में भी बहुत ग्लेरिंग चेंज था वो, क्योंकि अभी टाड़ा है ही नहीं, एंड वो सिलेबस में रिफ्लेक्ट हो रहा है वो काफी। तो देर इज 16 to 17 पेजेस। मैंने आपको भेजा है मेल, और अस्मिता मैम को। अस्मिता मैम को। अभी किसको भेजना है, ये संजना सावंत मैम को? हाँ हाँ। हेलो। हाँ हाँ सर, ये संजना सावंत मैम को भेजना है। हेलो। हाँ हाँ। हाँ, मैंने किया है मेल उनको। हेलो। आपको किया है, और हाँ हाँ, उनको बता दिया है। और एक दीपाली मैम इसका एडमिनिस्ट्रेटिव लॉ का कर रही है, वो भी भेजती हूँ, जस्ट 5-10 मिनट। हेलो। हेलो। हाँ, वो भी भेजती हूँ सर, आई जस्ट सेंड इट राइट नाउ। ओके सर, ओके। ओके सर।
हेलो मैडम।
हेलो। गुड आफ्टरनून सर। हेलो। गुड
हेलो
आफ्टरनून।
बिंदिया मैडम।
हेलो।
Hello, Swati ma'am.
या गुड आफ्टरनून।
Good
हेलो।
afternoon, ma'am. This is Rohit from UCC.
यस रोहित सर,
Yeah,
बोलिए।
so ma'am, there is to be a national anthem played before the
यस यस।
Yes, sir.
webinar. So
यस।
just give a little announcement before playing that song. So we will play from my side. Bindia ma'am, I think Bindia ma'am is going to, anchor this.
ओके।
Yes, yes.
ओके।
Ma'am, I'm going to start this program with your permission. May I?
Yeah, surely we can
Yes,
commence the event with there.
yes. Good evening, distinguished guests, teachers, and students. I'm delighted to welcome you all to the online international lecture series organized by Department of Law, University of Mumbai. And topic for today's webinar is terrorism, the use of force and self-defense. Before we begin with the educational journey, I request you all to please stand up for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल वंग विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you. Thank you all. Now I request Ms. Bindia to welcome our Head of Department, Coordinator and Honorable Guest.
Thank you, dear. First and foremost, I would like to convey my heartfelt gratitude to Dr. Alka Patil ma'am for giving me this great opportunity to introduce to the audience with our honorable head of the department and Professor Dr. Swati Rautela ma'am yet again. I, Bindya Khan, a former student of the Constitutional Group and a volunteer, feel incredibly privileged and proud to virtually honor our beloved and esteemed professor, Dr. Swati Rautela ma'am. Her kind and calm demeanor has profoundly impacted the lives of all students, faculty, and staff, earning her admiration and love from everyone in the global academic community today. Our esteemed professor has made significant contributions to this institution, serving as an LLM and research guide for MPhil and PhD students and coordinating the postgraduate diploma in intellectual property rights for about a decade. To highlight some of her remarkable achievements and lasting legacy, Dr. Swati Rautela ma'am has over 35 years of teaching experience, surpassing the lifetime of many of us. She taught business and mercantile law for almost 20 years at the renowned S.K. Somaiya College of Arts, Science and Commerce in Mumbai. She has participated in and presented research papers at national and international conferences, published research articles in UGC recognized journals, and was invited to contribute as a resource person for a UGC sponsored online refresher course in law organized by UGC HRDC Gujarat University, Ahmedabad. She coordinated with KC Law College for a 2-day international seminar as well. She presented a research paper at the
Bindia, be brief.
Yes.
Bindia, be brief. Just try to wind up.
Okay, ma'am. Dr. Swati Rautela ma'am's unwavering commitment and dedication to academics and her stable career are truly commendable. She is praised for her simplicity and selfless service to institution, treating everyone equally. It is my immense pleasure to describe her excellent nature and caring behavior, which I have personally experienced. Dear ma'am, you will always be an inspiration to every student and teacher due to your dedication to the field of law. We have endless words of gratitude for you, and you will be forever remembered. Now, I would like you to please virtual felicitate our honorable guest professor, Patrick C.R. Terry, Dean of University of Public Administration, Kiel, Germany. Thank you.
Dear colleagues, this is an honor to be on this platform. So, Honorable Professor Patrick Terry, sir, welcome to this international conference, and we are indeed pleased to have you over here, sir. And on behalf of Department of Law, I take this opportunity to greet you, welcome you. And today our students are wanting to listen to you into the different aspects of war, terrorism, whether it is a mechanism to defend the boundaries of the nation or whether it is a mechanism to take over. So there are several aspects into the same. And we all are into the war zone where we are seeing in the Middle East, the war is going on. We are also seeing the war is continuing between Russia and Ukraine. And the impact of war is going to be for all the generations to face. And we are seeing how the United Nations, it is difficult for them to control or to stop the war at this juncture. So we are really worried, sir, that it may end into a third world war, which will be very chaotic and disastrous in nature. And sir, you are having the experience of speaking into this domain of war, protective defense mechanisms, and being the dean in international laws, and especially in relation to laws relating to war, war crimes, and United Nations. We are really pleased to welcome you and pleased to listen to you. So on behalf of my Department of Law, University of Mumbai, and behalf of all the teachers in the department and the students of the Department of Law, I welcome you to this forum to have a discourse, dialogue into this topic. I sincerely thank the efforts which have been initiated by Dr. Alka Patil for having this, organizing this event. Also, I thank Kavita Bohra, who is a student and who is hosting the event. And rather than being a bridge between the students and you, sir, we will want to hear more of your deliberations. So thank you, sir. Welcome to this forum. Welcome, sir.
Dear Professor, thank you very much for inviting me. Oh, sorry, Dr. Patil.
Yeah, yeah. Patil wants to speak. Dr. Patil wants
sorry.
to speak. Yes, sir.
Ma'am, I have a welcome speech for the sir. Can I start?
Yes, please.
Yes, yes. Today, it is my great honor and privilege to welcome Professor Patrick C.R. Terry to our gathering today. Professor Terry is a distinguished scholar, educator, and leader in the field of law, whose contributions have significantly enriched the academic community and beyond. Professor Terry completed his PhD in law at the University of Kent in Canterbury, where his thesis on Great Power Interventions in the Middle East since 1970 provided profound insights into the complex interplay between national interests and international law. His academic journey is marked by excellence, having also earned an LLM in international law with international relations from the same institution, graduating with distinction and receiving an Academic Achievement Prize. In addition to his impressive academic credentials, Professor Terry has extensive professional experience. He currently serves as the Dean of the Faculty of Law at the University of Public Administration in Kiel, Germany, where he has been instrumental in restoring and strengthening the faculty. Under his leadership, the faculty has expanded and its academic programs have flourished, including the recent addition of a PhD degree course. Professor Terry Sir's dedication to teaching is evident from his outstanding student evaluations and the introduction of highly sought after seminars. His expertise spans a wide range of legal disciplines, including civil law, public international law, and constitutional law, taught in both German and students and colleagues alike. Beyond the classroom, Professor Terry Sir has made significant contributions to legal scholarship through his numerous publications in esteemed journals and his participation in international conferences. His research interests, including the use of force, state recognition, and cyber espionage, address some of the most pressing issues in contemporary international law. As a former judge and public prosecutor, Professor Terry Sir brings a wealth of practical experience to academic endeavors, enriching his teaching and research with real-world perspectives. His work as a judge in Germany was marked by exceptional performance and high praise from his peers and superiors. Professor Terry Sir's leadership, scholarship, and commitment to the rule of law make him an invaluable member of the academic community. We are incredibly fortunate to have him with us today. Please join me in extending a warm welcome to Professor Patrick T.R. Terry. We look forward to your insights and contributions to today's discussions. Thank you, sir. Welcome.
Thank you very much for that very kind welcome. Thank you, professors, for organizing this meeting and for inviting me to speak to your students today. on the topic of terrorism, the use of force in self-defense. I don't think I have to add anything to that extensive introduction. Thank you very much once more for your kind words. If you don't mind, I don't know, Dr. Patil, do you want to add something before I start the lecture? Because I've had the feeling I interrupted you beforehand.
No, sir. No, please, sir.
Okay, so I'll try to get my presentation. I'd like to share my presentation, but I just get the message that that's not possible.
We try to connect our technical team, so within 2 minutes he will, so that you can share your screen, sir.
Okay, so I'll start without the presentation, and hopefully when it is possible, I will share the screen. So as I've just said, the topic will be terrorism, the use of force in self-defense, which, as my esteemed colleague just pointed out, is a very timely topic, especially looking at the situation in the Middle East, with Israel trying to destroy Hamas capabilities in Gaza following the Hamas attack on Israel of October the 7th, 2023. And Israel is, of course, justifying its use of force in Gaza on the basis of a right of self-defense. And there have been many other instances where states have claimed a right of self-defense in response to terrorist attacks. Now, what is special about this topic? Basically, the issue at hand is, does a state really have the right to use force against another state in self-defense in response to a terrorist attack, that is an attack carried out by a non-state actor, even when the state attacked is not complicit in this terrorist attack? So that's basically the issue we will be talking about today. So the structure of my lesson is that, first of all, we will be looking at the proposition we will be discussing. Then I will be turning to the three major legal issues we have to deal with when discussing this topic. And that is, first of all, we have to look at the issue of whether terrorism, what is terrorism, who is a terrorist, is internationally defined. Is there an internationally agreed definition of the term? Because that can potentially, of course, lead to explosive situations if you have attacks by non-state actors where there's disagreement on whether these actors actually are terrorist in nature or not. Having discussed that, we will then move on to the UN Charter that contains rules on the use of force in self-defense. We will first look at Article 2.4 of the Charter, which contains the ban on the use of force in international relations. And then we will move on to one of the few exceptions the Charter provides for using force, which is Article 51, which grants states the right to self-defense, before then reaching a conclusion. So starting out with the proposition we will discuss, and it's very important at the outset that we are on the same page as far as the topic is concerned. We will be discussing the proposition that terrorist attacks carried out by non-state actors, the terrorists, justify the use of force in self-defense.
Sorry to Dr. Patrick. Now you can share your screen. It's done.
That's good. Excellent.
Thank you.
So that should now be showing, I hope, soon. Can you see my screen?
Yes, sir.
Okay, and then move on to here. So hopefully that will work. That is not, yes, okay. So now we have gone through the structure of the lecture, now been moving to the proposition that we are discussing, which is that terrorist attacks carried out by non-state actors, terrorists, justify the use of force in self-defense. by one state against another state, even when that state is not complicit in the terrorist attack, but rather only unable or unwilling to deal with the terrorists on its territory. So to make that one very clear once again, we will not be discussing cases where the terrorists are claimed to have, the terrorist act is claimed to have been instigated or otherwise supported by the state against which force is used. So we've had cases like that in the past. For example, in 1986, a bomb went up in a West Berlin discotheque, which was frequented by US servicemen. And then US President Ronald Reagan claimed that that terrorist attack had been instigated by Libya's leader Gaddafi, and then launched airstrikes against Libya, claiming a right of self-defense. Here, the legal problems are much less than in the topic we will be discussing, because if true, then basically it would have been an attack by Libya against United States interests. Similarly, in 2003, an alleged assassination plot was uncovered, according to which former US President Bush Sr. was to be assassinated while visiting Kuwait, and the United States claimed that this had been instigated by Iraqi security services, and the United States, claiming self-defense, then launched an attack on Iraq in response. So these are issues that we will not be dealing with, because in that situation, you have the claim that the other state is instigating or supporting the terrorists in attacking the victim state, and therefore the issue of self-defense becomes much less contentious. Although there were discussions at the time about the scale and gravity of the attacks, basically that is not problematic. We will only be discussing cases where the state attacked is not accused of being complicit in the terrorist attack having been carried out. And two examples, both again US-led military actions, would be the Al-Qaeda terrorist attacks against the US embassies in Kenya and Tanzania in 1998, to which the United States responded by attacking Al-Qaeda bases in Afghanistan and a chemical factory in Sudan in 1998. And here we have a situation whereby the United States was launching an attack against the territory of a state that was not involved, even according to the United States, was not involved in the original terrorist attack. And of course, we all know about the decades-long war in Afghanistan, launched in 2001, Operation Enduring Freedom, carried out initially by the United States and the United Kingdom, both states claiming self-defense in response to the 9/11 attacks by Al-Qaeda on the United States. And again, neither the United States nor the United Kingdom claimed that the Taliban government of Afghanistan was responsible for these terrorist attacks, but rather claimed they were either unwilling or unable to deal with the Al-Qaeda terrorists on their territory, and that therefore, in their view, justified the use of force in self-defense. So that is the issue we'll be looking at. And the first big problem, if we talk about using force in response to a terrorist attack, is the issue of whether there is a general international definition of the term terrorism. And I refer to the very often repeated statement, one man's terrorist is another man's freedom fighter. This statement is often quoted, often attributed to former US President Ronald Reagan, and it is true that as far as many groups are concerned, there is international disagreement on whether these groups are to be seen as terrorists or not. So looking at the current situation in the Middle East, as far as Hamas is concerned, Western states and many other states are in complete agreement that Hamas is a terrorist organization. However, if you look at Arab states, many Arab states, or at Iran, they see Hamas as the representative of a subjugated people, the Palestinians, and therefore are closer to arguing that Hamas actually belongs to a sort of freedom fighter group category. So that is the big weakness we do have as far as terrorism is concerned. There is no consensual international definition of that term. Some criteria have been developed. I'll be moving on to that shortly. But as I said, there is no general agreement as to who or what is a terrorist, leading states to come to completely different conclusions. That doesn't only apply to Hamas, it also applies to, for example, Hezbollah in Lebanon, or to Iran's Revolutionary Guards, which the United States, for example, views as a terrorist organization. Many other states do not, certainly not yet. Now, moving on to these general criteria states appear to have agreed on, I'm basing what I'm saying now on a very newly published report, a commentary issued by the Executive Directorate of the UN Security Council Counterterrorism Committee, and it was published in June 2024, so it's really new. And they, having reviewed all the international instruments dealing with terrorism, conventions, treaties, resolutions, have come to the conclusion that there's international agreement as far as 4 general criteria are concerned. So they say terrorist act is an act of violence, an intentional act of violence with an intentional serious outcome. And this intentional act of violence is undertaken for a terrorist purpose. Now, I hope if you look at that, you already see that, of course, these are very general terms. And that already explains to some extent why states have come to differing conclusions as far as specific groups are concerned. So looking at these 4 general criteria, we see some examples of that in these international instruments. For example, the 1999 International Convention for the Suppression of the Financing of Terrorism is a good example. And why did I choose that? Because it was adopted by the UN General Assembly and ratified by now by 189 states. So it does seem to be reflective of what states agree upon as far as terrorism is concerned. Although the convention as such doesn't deal with the crime of terrorism, but only with the financing of terrorism. And you find the definition of terrorism according to which it is an act intended, so you've got the intention, to cause death or serious bodily injury, which is the serious outcome to a civilian. And then you have the purpose to intimidate a population or to compel a government. So you have the terrorist purpose. Turning to the other major international organization which deals with these issues, the UN Security Council. The UN Security Council, although having dealt with terrorism in many resolutions prior to 2004, always, especially in the aftermath, of course, of 9/11, the attack on the United States by Al-Qaeda, the UN Security Council always avoided defining the term terrorism. So one of the first definitions to be found is actually comes from UN Security Council Resolution 1566, 2004. And again, you find these 4 criteria I mentioned. You have the intent to cause death or serious bodily injury. They have added or the taking of hostages, and then the terrorist purpose of provoking a state of terror, intimidating a population, or compelling a government or an international organization. So again, this resolution reflects the 4 core criteria as far as terrorism is concerned. And in 2017, the UN Security Council expanded the serious outcome to include the destruction or the disablement of critical infrastructure. So we have these general criteria. One major criticism, however, I do have of this report of June 2024 is that it demands an act of violence on the part of the terrorists. That, in my view, ignores the fact that nowadays, of course, serious outcomes can be achieved by cyber means. So I think demanding an act of violence for an act to be terrorist is probably a little outdated, but I'm sure states will get round to including that as a possibility as far as terrorist acts are concerned. So what is my conclusion as to this section, international definition of terrorism? Yes, states have come together and have agreed on some general criteria according to which they define a group as terrorist. However, because these general criteria are rather vague, there's disagreement when applying these criteria to specific groups. So as I said, states have come to very different conclusions, especially in the Middle East, looking at groups such as Hamas, Hezbollah, or Iran's Revolutionary Guards, where some states are in agreement that they are terrorists in nature, while other states disagree and see them in the sort of freedom fighter category. So that is one of the major legal problems we have when we talk about using force in self-defense against the terrorist attack. We will now be moving on to the UN Charter. Now, before we look at these rules, the discussion I will now be having as far as the UN Charter rules are concerned is based on the assumption that it is not contentious whether a terrorist attack has taken place. There are groups in the world where states are in agreement that these groups are terrorist in nature. For example, Al-Qaeda or ISIS. There's agreement among states that these groups are to be viewed as terrorist organizations. So the legal analysis that now follows is based on the assumption that the attack has been carried out by a group which is recognized as being terrorist in nature. Now, the first issue we have to deal with if a state responds to a terrorist attack by using force in self-defense is Article 2.4 of the UN Charter, because Article 2.4 of the UN Charter contains a ban on use of force. This is the text of Article 2.4, which states that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. Now, I've highlighted the second part of Article 2.4 because that is where the legal discussion begins. That is the first contentious issue as far as using force in self-defense against terrorists is concerned. Because there are two views as to the meaning of the second part of Article 2.4. There's the minority view, according to which the second part, which I've again put at the top of the screen, according to which this part of Article 2.4 limits the ban on the use of force. So a minority of scholars argues that the use of force is only banned in Article 2.4 if directed against the territorial integrity, political independence of another state. Transferred to terrorist attacks, they would argue that if a state responds to a terrorist attack by attacking terrorist bases in another state, that does not threaten the territorial integrity or the political independence of that other state, and therefore does not violate Article 2.4. So for them, the issue would be closed at this point. However, as I said, that is the minority view. The majority view says that Article 2.4 contains a complete ban on the use of force, and that the second part of Article 2.4 is only meant to provide examples, and that this is evidenced by the negotiating history. Now, my view on that is that the majority is correct. Article 2.4 does contain a complete ban on the use of force, and I have three reasons for doing so. As the majority view already states, looking at the negotiation history, looking at the travaux préparatoires, which you are allowed to consult in order to interpret a treaty norm, it becomes evident that the second half of Article 2.4 was only included at the wish of newly independent, weak states that wanted to include an ironclad guarantee of their newly won independence in the UN Charter. So this second part of Article 2.4 was never meant to limit the ban on the use of force, but was rather only meant to provide examples of the prohibited use of force. Secondly, the International Court of Justice has, since its very early days, since 1949, repeatedly rejected the narrow interpretation of Article 2.4. In the Corfu Channel case, which was a case between the United Kingdom and Albania, the United Kingdom had argued as follows. There were mines laid in Albanian territorial waters, and it was unclear who had laid those mines. And the United Kingdom decided to remove those mines from the Albanian territorial waters against the express wishes of the Albanian government. And when the case came before the International Court of Justice, the United Kingdom argued that this action, removing the mines against Albania's wishes, had not been directed against Albania's territorial integrity or against its political independence, but rather had only been undertaken in order to secure safe passage for other ships and in order to secure evidence for a future court case. And the ICJ already in 1994 rejected that argument and said that this form of self-help was not justified and was just another term for an unlawful intervention. And then lastly, we have UN General Assembly resolutions which also negate the minority view, especially the definition of aggression, Resolution 3314 of 1974, which is in its articles 1 and 3, when defining the act of aggression, clearly does not limit the aggression to attacks against the political independence or territorial integrity of another state. Now, of course, UN General Assembly resolutions are not legally binding, but can be seen as reflective of customary international law, especially if they have been passed by consensus, and there's agreement that the definition of aggression is now seen as reflective of customary international law. So in summary, I would say that Article 2.4 contains a complete ban on the use of force, which for our topic means that if a state responds to a terrorist attack by attacking terrorist bases in another state, and if that state was not complicit in the terrorist act, then the state is violating Article 2.4, the ban on the use of force. But the story doesn't end here, because the Charter does provide exceptions to the ban on the use of force. And of course, as the topic today already indicates, the major exception to the ban on the use of force in the UN Charter is the right of self-defense, as found in Article 51 of the UN Charter. Now, here we have the text of Article 51, which states basically that nothing in the present Charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations. Now, again, there's a big controversy as to whether terrorist attacks are included in this term if an armed attack occurs. What is the issue at stake? Well, on the one hand, many scholars and states argue that the armed attack has to be carried out by another state, has to be imputable to another state for the right of self-defense to be invoked. While others say, no, it's just sufficient that an armed attack has taken place for the right of self-defense to be invoked, no matter where that armed or from whom this armed attack originates. So again, we have a dispute, two major polars as far as this issue is concerned. So we have the one hand, the people that argue, no, the right of self-defense can be invoked even if the armed attack is not imputable to another state. And they quite rightly point to the text of Article 51. Going back, you see that a state is not mentioned. It simply states if an armed attack occurs. It does not state if an armed attack by another state occurs. Secondly, these scholars and states argue that the phrase in Article 51, inherent right of individual or collective self-defense, meant that all pre-charter cases when self-defense was justified were incorporated into the UN Charter. So they argue that Article 51, the right of self-defense against an armed attack, is only one example for self-defense, but that there are many other cases also justified as self-defense because the UN Charter drafters had included all pre-Second World War rights of self-defense in the Charter by using the term inherent. And they then point to the 1837 Caroline incident. Now, you may have heard of the 1837 Caroline incident already, because it is often discussed in the context of anticipatory self-defense. But it is also discussed in the terrorist context. What happened in 1837 was that Canadian rebels who were rebelling against British rule had commandeered an American ship named Caroline, and that ship was moored in American territorial waters when the British attacked the ship. And in the subsequent discussion between the US and the UK government on whether this action was justified, the issue of self-defense was discussed. And there was disagreement between the United States and Britain on whether Britain was justified, but it was not relevant in the discussion that the actors, the Canadian rebels, were non-state actors. So the argument continues that already in 1837, it was permissible to use force in self-defense against non-state actors, and that this right had been included in the UN Charter by using the phrase inherent right to self-defense in Article 51. And then lastly, there's a third group of scholars that acknowledges that originally Article 51, the right of self-defense, was only applicable in cases when the armed attack had been carried out by another state, but argue that since Operation Freedom had been launched in response to the 9/11 attacks in 2001, changes in the law have occurred, and that states now accept a right of self-defense against non-state actors, even when the state on whose territory the terrorists are located are not complicit in this terrorist attack. So that is one view of Article 51. The other view is that Article 51 does demand that the armed attack being carried out is imputable to another state for the right of self-defense to be invoked. And they also have three reasons for arguing that way. First of all, they point out to the drafters and the general view until 2001. So basically, already at the time when the UN Charter was drawn up, this was being discussed. And for example, the Foreign Relations Committee of the US Senate, when dealing with Article 5 of the NATO Treaty, which is very similar in phrasing to Article 51 of the UN Charter, pointed out that the article only came into operation when a nation had committed an international crime by launching an armed attack against the party of this treaty. So they obviously were of the view that the armed attack had to be imputable to a state for the right of self-defense to be invoked. Similarly, staff members of the US Senate Committee on Foreign Relations concluded, as far as Article 5 of the NATO Treaty is concerned, this rules out violence of irresponsible groups and refers, as Article 51 of the Charter clearly contemplates, to an armed attack of one state against another. So at the time the UN Charter came into force, there seems to have been an agreement that the armed attack had to be carried out by a state for the use of force in self-defense to be justified. Secondly, they point to the definition of aggression, which I already mentioned, the General Assembly Resolution 3314 of 1974, which is seen as reflective of customary international law. And here we have an Article 3 defining the act of aggression, and Article 3G expressly deals with the issue of non-state actors. And this definition of aggression includes non-state actors and says that this only then amounts to an act of aggression if the non-state actors have been sent by or on behalf of another state. So the definition of aggression would also imply that the use of force, the armed attack, had to be imputable to a state for the right of self-defense to be invoked. And the last argument brought forward is that although many instances have occurred since 2001 when states have invoked the right of self-defense following a terrorist attack, that there's still no general agreement among states that that is lawful under Article 51, and that therefore customary international law has not evolved to such an extent that you could say the use of force is justified under Article 51 if the state concerned is not complicit in the terrorist attack. Now, what is my assessment of this discussion? Basically, based on the treaty, I would agree with those that say, yes, an armed attack has to be imputable to a state for the right of self-defense to be justified against that state. First of all, it is true that that was the general view until 2001. As Judge Korsmans of the ICJ in a separate opinion pointed out, that was the general view, at least until 2001, that Article 51, the right of self-defense, only applied if the armed attack had been carried out by a state or was being carried out by a state. Secondly, the International Court of Justice, in its advisory opinion of 2004, dealing with the war on the being constructed on occupied Palestinian territory, explicitly stated that Article 51 of the Charter recognizes the existence of an inherent right of self-defense in the case of armed attack by one state against another state. So the ICJ in 2004 still was of the view that the armed attack in Article 51 had to be carried out by a state, meaning that terrorist attacks, not imputable to a state, were not covered by Article 51. And lastly, the definition of aggression, I've just referenced, Article 3G, has not been repudiated by any state. So states are still claiming that the definition of aggression reflects customary international law. In fact, in 2010, the state parties to the Rome Statute of the International Criminal Court again used the definition in 3G in order to define the crime of aggression. So basically, as I said, 3G states that non-state actors, an act of aggression only exists if non-state actors have been sent by or on behalf of the state to carry out the aggression. However, having said that, as far as the legal position is concerned, I think it would be completely amiss not to acknowledge that state practice is definitely moving in the other direction. So it is definitely the case that state practice is increasingly moving in the direction of accepting the use of force against terrorists in response to a terrorist attack, even if that act is not imputable to another state. This has been happening since the late 1940s, one can say. Already in the late 1940s and 1950s, Israel attacked Palestinian bases in neighboring countries and claimed a right of self-defense. Later on, Turkey joined the fray, attacking alleged Kurdish terrorist bases in neighboring countries. However, the real watershed, I think, was when the United States decided to join the fray, which was in 1998. I mentioned this already, when the United States, in response to the attack on the US embassies in Tanzania and Kenya, launched strikes against Al-Qaeda bases in Afghanistan and the chemical factory in Sudan. And the US Congressional Research Service at the time concluded that this was the first time the United States had attacked a country with which it was not at war, and also said that it was of doubtful legality. And then moving on from 1998, of course, the real watershed moment, Operation Enduring Freedom in 2001, where the United Kingdom and the United States, claiming a right of self-defense, attacked Afghanistan in the follow-up to the Al-Qaeda terrorist attacks of 9/11. Neither the United States nor the United Kingdom claimed that the Taliban government were complicit in the terrorist attacks. Nevertheless, they claimed the right of self-defense, and a far-reaching right of self-defense, not only attacking the terrorist bases, but actually claiming a right to remove the government of Afghanistan. And since then, there have indeed been many, many instances of state practice where states have claimed a right of self-defense against terrorists on other states' territory. So Turkey has repeatedly attacked bases, alleged Kurdish terrorist bases in northern Iraq and Syria. Russia attacked alleged Chechen terrorist bases in Georgia in 2002, declaring that it was an action in self-defense. Colombia bombed FARC bases in Ecuador in 2008. There are also many African examples, usually involving Somalia. Then, of course, we have the situation in Syria following the civil war that erupted in Syria when the ISIS terrorists established bases in Syria. And in the end, more than 60 states, including NATO, attacked ISIS bases on Syrian territory and claimed a right of self-defense without any noteworthy legal objections in the international community. We also have the ongoing targeted killings whereby many states, including the United States, the United Kingdom, and Israel, claim the right to kill alleged terrorists on the territory of other states. And again, there's hardly any negative international reaction as far as the legal implications are concerned. And of course, we have the current situation in the Gaza Strip. And again, there are only few states that dispute that Israel has a right of self-defense. And even among those states that dispute Israel's right to self-defense, many argue that it's not based on self-defense not being available as far as non-state actors are concerned, but base their objection on the fact that they claim Gaza is occupied territory and therefore Israel could not invoke the right of self-defense. So overall, I would say that there can be no doubt, in my view, that states are increasingly willing to accept the use of force by one state against terrorists in another state as a legitimate exercise of self-defense, even when the terror act cannot be attributed to the target state. And basically, of course, I think probably many of you would agree that does seem a sensible position. If you have a state unable or unwilling to deal with terrorists on its territory, that you should give the attacked state the right to respond. On the other hand, of course, one always has to be aware of the fact that that kind of attack on terrorist bases is rarely targeted in a way that does not involve civilian losses and destruction of infrastructure in the target state, which is especially problematic in cases where one can argue that the state is unable to deal with the terrorists on its territory, because it is being, one could argue, punished for something that it cannot really be blamed for. So it is problematic in my view, but I think there can be no doubt that at least customary international law is moving in the direction, perhaps has even arrived there already, whereby the use of force in self-defense against non-state actors is permissible. So overall, my conclusion would be, as far as this lecture is concerned, that states are increasingly prepared to accept the use of force against terrorists or self-defense in cases when a state is unable or unwilling to deal with the terrorists on its territory. But we do still have that problem that there's no agreement on who or what is a terrorist. So that can potentially lead to explosive disputes. Only one small example. There was, as many of you will know, a coup attempt carried out against President Erdogan in Turkey. And he subsequently blamed a religious organization called the Gülen Movement and declared them to be a terrorist organization. Now, the leader of that movement legally resides in the United States. Now, of course, based on President Erdogan's view of the Gülen movement and based on a right of self-defense against terrorists, the issue then would arise, is President Erdogan perhaps justified in using force to at least take out the leader of the Gülen movement, even if he's on territory, on US territory? So that's just a small example that shows you that this failure by the international community to agree on who is a terrorist can lead to things escalating very badly and potentially leading to major conflict, as my esteemed colleague pointed out at the beginning of this lecture. And now I'm happy to discuss or answer any questions there may be as far as the lecture is concerned.
Thank you so much, sir. Now we are moving on to question answer session. Some of the students have sent us few questions, so I would like you to answer them.
Yeah.
Can we take?
Of course.
Okay, sir. With your permission.
Of course.
Yes, sir. So first question we have that in the context of international law, can groupism, where a coordinated group and acts against an individual, be considered an act of terrorism? How does the legal framework address scenarios where the power dynamic is one versus many?
I'm not quite sure I understand the question. Could you perhaps rephrase it? One against the many in what
Yes, sir.
context?
I will repeat for you. Sir, can you hear me?
It's a bit
Sir, am I
disruptive, but
audible?
yes.
Hello.
Yes, I'm listening.
Yes, sir. I'm repeating the question.
Yeah.
A group means a group targeting a individual,
Mm-hmm.
okay, be considered an act of terrorism. And how does legal framework address these scenarios where power dynamic is one versus many, means one individual and many people in a group?
So basically, I would argue that a group attacking an individual, depending on the purpose of that attack, can be terrorist in nature, yes. However, it is most likely, depending on the context, an issue for domestic criminal law rather than international law, I would have thought. But I think, of course, there are cases, undoubtedly, where a group attacking an individual can be terrorist. It depends
Okay, sir,
on the purpose of the attack.
Okay, sir, thank you so much. And the other question is, can the conflicts between Israel and Palestine and Russia and Ukraine be considered instances of state terrorism? Are there any connections or similarities in how state terrorism manifests in these conflicts?
As far as state terrorism is concerned, basically you would have to use the internationally agreed criteria in order to define whether a state is committing terrorist acts. So you'd have acts of violence with a serious outcome, which you of course always have in a war or when fighting erupts. But the issue is there a terrorist purpose? Are these actions being carried out for terrorist purposes? Now, as far as the current conflicts are concerned, there are some who argue that Israel or Russia are guilty of state terrorism, and there are many who would disagree with that proposition. I think you would have to look at individual acts to come to a clear result. I don't think you can have a sweeping assertion that everything Russia or Israel does is state terrorism. Basically, I think I would be careful before coming to that conclusion.
Okay, sir. And the last one we have is, what do you see as the future of terrorism and counter-terrorism efforts?
Well, unfortunately, I'm rather pessimistic as far as terrorism is concerned. It seems that we are, as my esteemed colleague mentioned at the beginning of our lecture, we are entering unstable times, and lots of states are in danger of failing. So I think we will see an increasing number of terrorism, often, of course, in the regional context, so not necessarily affecting all parts of the world. And I think that it is very difficult to deal with terrorists because while it is always possible to destroy terrorist bases and to kill individual terrorists, the problem is, as in fact, I think an Israeli military spokesperson said about Hamas, the problem is that very often you have this ideology that is spread among people that survives any military conflict. And that, of course, the counterterrorism efforts, justified as they may be, often create additional conflict, additional hate, additional aggression on the part of those who are fighting against what they view as or fighting for what they view as a just cause, which we would probably describe as a terrorist cause. So I think in both respects, I'm rather pessimistic as to future developments because I think we are entering very unstable times all over the world.
That's so kind of you, sir. Now we move towards the vote of thanks. On behalf of Law Department, Mumbai University, I would like to extend my heartfelt gratitude to everyone who has contributed to the success of today's event. First and foremost, a big thank you to Professor Patrick Terry, sir. Your insights and expertise have greatly enriched our understanding of terrorism, the use of force, and self-defense. We are deeply appreciative of the time and effort you have put into preparing and delivering such an engaging presentation. I would also like to express our sincere thanks to Dr. Alka Patil ma'am and Dr. Swati Rautela ma'am. Your contributions have been invaluable and your efforts is truly inspiring. Our appreciation also goes to all the faculties, technical and non-teaching staff who have supported and guided us throughout this journey. Last but certainly not least, thank you to one and all our viewers. Your participation and engagement are what make these events meaningful. We hope appreciate your time and interest, and we hope you find today's session valuable. Once again, thank you for all making this event a memorable and successful one. We look forward to your continued support and participation in future endeavors. Thank you so much.
Thank you very much for inviting me, and I very much enjoyed giving the lecture. And thank you, Dr. Patil, for organizing everything.
Thank you so much, Dr. Patrick, sir.